Hello, I'm Greg Benner. I'm a realtor who specializes in probate in Clark County, Nevada, as well as Nye County, Nevada. I'm also a certified probate expert. I have heard the frustration in so many people's voices because they cannot get a straight answer as to what to expect going through probate. So today, I will be presenting a general timeline of the probate process here in Clark County, Nevada. I hope this answers a lot of your questions. First, your attorney will petition the court for the specific type of administration you are seeking, which is based on the value of the estate, as well as for the appointment of the personal representative administrator for the estate. If you do not have an attorney yet, please make me aware of this. I know the probate attorneys, and I will provide you with referrals to competent and experienced probate attorneys here in Nevada. Your attorney will also petition the court for a notice of hearing, which will cause the clerk to schedule your court date. Here in Clark County, Nevada, as of August 2023, those dates are approximately set 3 to 4 months out. You see, here in Clark County, probate court is held once a week on Fridays at 9:45 a.m., and they only handle up to 150 cases to be heard each week. So once those 150 slots are filled, they move on to the next week in the scheduling process. If there are holidays, which may affect things, that will also come into play in the scheduling process. Your attorney will then mail the information out and submit to the courts a certificate of mailing. Now, here we are 3 or 4 months down the line, and we come to your court hearing. This is where the commissioner will grant the petition for appointment of personal representative or administrator, grant the specific type of administration you are seeking, again, based on the value of the estate, as well as grant the letters of administration or testamentary, which grant the authority to make decisions on behalf of the estate. Usually, in the following week's time, an order appointing the administrator, the type of administration, and for the letters is entered. Immediately after, expect the letters of administration to be electronically issued and filed. Once those letters have been issued, then you and I can enter into a listing contract for the sale of any real property. During this time, there will be a notice to creditors, which will be posted for 60 days. This allows any entity to claim they are owed monies from the estate to do so. This may be credit card companies, Medicaid, medical providers, hospitals, etc. Now, remember that once those letters have been issued and filed by the court, we can now list any real property for sale in the market. This is where you will want to make sure you are working with a certified probate expert realtor, such as myself. Probate real estate is much more complicated than the traditional sale of real estate. And when things are not filed correctly with the courts, when the correct language is not used in contracts, when some tricks of the trade are not used, you may find that later on the deal falls apart and you have to start all over again. This not only creates months of delay, but also leads to an increase in legal fees. And I'm sure we all realize legal fees are not just nickels and dimes. So let's say you did the smart thing and you are working with a certified probate expert realtor. Your listing was entered into the MLS correctly with the proper language for a probate listing, and you have now received an offer. The current median days on market is 49 days. So that could be more or less, depending on a lot of factors, as well as taking into consideration the length of this process in totality to this point. Then we need to wait until all buyer due diligence contingencies and loan contingencies are completed before the next step. Now, it is very important that the correct protections and addendums are used to protect all parties and to make them aware of the unique challenges of probate real estate. Did you know most real property sales and probate must be approved by the court? Well, they do. This is known as the confirmation process. And that means once your offer has been received, the necessary steps for probate have been submitted via counteroffer, and the offer finally accepted. Congratulations. And the contingencies completed, let's say 60 days for that. Now your attorney must submit a petition to confirm the sale of real property to the courts. Once that petition has been filed, it will be another 4 to 6 weeks for the confirmation hearing to be scheduled. I have found it to be vitally important that I also review a copy of the file-stamped petition to confirm the sale of real property as soon as possible. Everything must be correct on the petition. If something is not correct and it is not found out until we head to the confirmation hearing, then we will need to start all over again by applying for another confirmation hearing. And this equals time lost and money lost. Now, once we get through the confirmation hearing, the closing of the transaction can move forward and usually occurs within the next couple weeks. Are there other considerations happening? Well, you bet. There is an opportunity for an interested party to overbid on the property, and that actually takes place right there in the courtroom in an auction type of procedure. I'll make sure to produce a video in the future which explains this a bit better. In the meantime, if you'd like to know more about the probate process, I encourage you to give me a call and schedule a time to go over your questions. As you can see, the timeline is extensive. First, 3 to 4 months for the first petitioned original court date, then an additional roughly 60 to 75 days for listing of real property, offer acceptance, and due diligence, then a 4 to 6 week wait period, again for a confirmation hearing. And we're not done yet. We've got to wait for all this to be officially approved and entered into the system, which may take 10 days. Finally, you are ready for the funds from the sale to be deposited into the estate trust account 10 days after that, for the creditors to be paid, and the final accounting to be approved so the courts can close your case. Whew. You made it. Please remember, there are major differences between the traditional sale of real property and that of probate real estate. You'll want to cut down on the errors which result in the loss of precious time and money. Taking advantage of a certified probate expert realtor like myself from the beginning provides you with the peace of mind you deserve. Hey, thank you so much for watching. I really hope this gives you a better understanding of what a probate timeline looks like. Let me worry about the details for you. I'm ready to chat when you are. Thank you so much for watching. Bye-bye.